Hello, John McConnin here with UpsideDownRealEstate.com and FavoriteRealEstate.com. I am an attorney, and we're still getting calls from clients that are working things out on foreclosures. So this is a foreclosure timeline. Um, I think one way to set this off, this is what I tell people in my office when I'm speaking with them or even over the phone. There are exceptions to the rule, and one of them is the loans made between 2003, the beginning of it, and the end of 2007. But for all intents and purposes, it only seems to buy an extra 30 days, and it might come in even in the beginning of the process. So it's going to be hard to know because lenders don't always start the foreclosure process at the same time. One of the things I tell my sellers, potential sellers, or loan mod people, or even foreclosure people, you sort of know you got switched on the software by the bank when you get that letter of acceleration, which before that you're going to get a lot of creepy things or scary things or fake looking legal notices from the bank and their collection department. But they're getting serious when you get the letter of acceleration saying you've got 30 days to pay basically the last 2 or 3 months payments you haven't made to get even with them. Otherwise, they're going to accelerate the whole loan due according to the terms of your note. And usually 30 to 45 days after the software gets turned on, you get that letter of acceleration, you'll get the notice of default. Now, this to me, we don't need to get into whether they've properly recorded it or not, whether you've been given proper notice, because homeowners should be, unless you plan to fight the foreclosure process and pay an attorney to do it, and that's expensive, and you better have, I would think, a good reason and an expectation of winning to want to waste your time and money doing that. So really, the notice of default means, hey, I didn't get started at the letter of acceleration, but I better pick something now and get working with the bank, whether it be a loan mod, whether it be a short sale. I need to talk to an attorney, find out what my leverage is, and make my decisions, because these are a short sale or a loan mod or even a foreclosure for clients with assets that they want to protect, and maybe they've got a recourse second. These are different tools. These are different things. It's like a scalpel to a surgeon. Not everybody should be a short sale. Not everybody should be a loan mod, and not everybody should be a foreclosure. But if you've got the type of bank that might be looking for big money and you've got a recourse loan and they don't know about your assets, maybe you want to keep it that way, or maybe for the same reason you want to keep things private if you've got a non-recourse loan. Maybe you want to position your assets ahead of time. And if you've got assets, you probably want to get involved. You get in touch with us before that notice of default, so you can spend 2 or 3 months positioning your assets so that when you answer the bank's questions in a short sale, and they all ask prying questions about your assets, but you can respond accurately, and hopefully you'll have anticipated the questions because you're working with someone who understands the bank's questions, and your assets won't be where the bank's asking about them. Answer accurately, that a bank doesn't get alarmed that maybe you've got a ton of money or 4 other properties, and now you've pre-positioned for your short sale. But nevertheless, notice of default, better get serious. Again, see us if you've got assets, talk to us. You still have time to do a short sale the right way with most lenders and pre-position your assets. This is the notice of default. This is where you're going to get that short sale paperwork in or get that loan mod paperwork in if the bank still accepts loan mod paperwork, because you're looking at 20 days from now, you're looking at what could be the trustee sale on the courthouse steps. Now, they don't always happen on this 120-day timeline between the notice of default and the notice of sale, but as they've gotten less busy, it's happened more often, on target, on time. But with the right negotiating team, you can usually get 30, 60, 90-day extensions. And if you look at my other video, if you approach the bank for a loan modification, they're supposed to delay and pause this whole process. So there are reasons to talk to people who know what they're doing. And remember, you don't necessarily want to see someone whose only answer for you is short sale. I think you want to customize your workout, how you position your assets, and what you go for based on your assets, your job, your desires to protect your credit, because there are ways to do that too when you're working with a lawyer, and even your credit history, which is a little different than your credit score. So once again, John McConnin, FavoriteRealEstate.com, UpsideDownRealEstate.com. If you're in California, we'll be happy to give you a consult. In fact, if you're if your property's not in California, your state's going to have other foreclosure timelines. Thanks.